My lord, with copy to my learned friend, my lord, as per instruction of your lordship. Hearing.
Hearing of
Civil division.
Inclusion.
Yes.
One or two.
One, another is communication.
Communication.
Item number one.
Item number one, I am praying for a short Passover, my lord. I am led by Son. That cannot be passed over. Sonak Bhattacharya. Mr. Sonak Bhattacharya is appearing in this matter. My lord, he is in his legs, my lord, for a short Passover. Passed over, my lord. For passed over, Lord Council, passed over for till my lord, half an hour. Second call করুন।
देनी तो तुम
ना दूसरी देनी तो
ठीक है তনুশ্রীকে কোণে এসো 21,000 21 হয়ে গেছে তো সবে 600
ये सारी
সাজিয়ে গেছি
नाम तो
সব ফাইল সাজিয়ে গেছি কালকে নিজে হাতে করে দিতে 21 8 এগুলো সব সাজানো ছিল কেউ হাত দিয়েছে কেউ হাত দিয়েছে না ফাইল হাত করেছে কেউ ফাইল হাত দিয়ে এটা তো ফাইলগুলো কালকে তো দিয়ে রেখে দিয়ে গেলাম বুঝছি 21,658 38 হয়তো রেখে দিয়ে গেছে আমি তো বলে উঠে গেছি ফাইলগুলো কোথায় নেবার আরেকটা সেলাই করা সব জাজমেন্ট করছি। ঠিক আছে, থাক পরে আয় ও না গায়ত্রী 38-20-20 তো তোর বোঝা না 38-20-20 ওখান থেকে রেখে দিয়ে গেলাম রেখে দিয়ে গেলাম।
সে টেবিলে ফাইল হচ্ছে, বাড়িতে কোথায় গেছে? বলছে টেবিলে ফাইল আছে, বাড়িতে কোথায় গেছে? আপনি নিয়ে আসুন ফাইলটা।
ও বাইকের উপর যেগুলো পাই হয় সেগুলোতে কোনো ফাইল পাঠাবে না, থাকবে না কোনো ফাইল। আমি এখানে সব সেট করবো। হ্যাঁ, দাঁড়া আগে ঘরটাকে এই ফাইলটাকে সেট করে নেই এক্ষুনি বল। 8 8 তো 21টা আমি ফাইল নিয়ে যে আমি নিচে নিয়ে আসছি 25 আগে আগে কোনো ঠিক 8 8 কালকে ছিল না, একদিন ছিল না, পাঠাতে পেরেছিল ওদেরকে বলে দিলাম পাঠাতে একটা এসছে আছে আছে 3 নাম্বার 3 নাম্বার 21,000 এক আছে
চেয়ারের টেবিল 100 ঘর হলো।
2 নাম্বারটা তোমার সিট আছে তোমার সিট
আমি জানতে চাই না কার কাছে আছে।
না 3 নম্বরটা আমার 2165
Well, so my lord, conspicuously absent. Let me start. They will come following the vote. They are under impression that since
আইটেম নাম্বার 2 করে দিন। দাঁড়ান রেডি, then we can take over the first one.
Red road is closed. Everyone is stuck. Even the learned advocate just was walking in the road.
বসো প্লিজ বসো না। তুমি একটু ঘুরে আসো, আমার 15-20 মিনিট হবে। I have no problem. May I come after? No problem.
Item number 1 thereafter
No problem.
you can take up
আইটেম নাম্বার 1
item number 1. In the meantime ফাইল যাবে না, ওই জন্য বারবার বলে দিচ্ছি, ঠিক আছে? শুধু অর্ডার শিট যাবে, ঠিক আছে? মানে রাত্রির অব্দি আমি
Corporation একটা এনেছো?
রাত্রির অব্দি বসে আমি সই করবো আর ফাইল নিয়ে হতে পারে না। ইয়েস,
Advocate যাওয়ার রাস্তায় পাঠিয়ে নেবে। অপূর্ব দা, advocate যা। Now, my lord, before proceeding further, not
so
kindly,
according to you the food property is situated within panchayat area.
yes. But now to substantiate that. Kindly takes up, my lord, the Howrah Municipal Corporation Act. Kindly see, my lord, the Schedule 1, which was prepared under subsection 2, section 2 of subsection 4. Schedule 1.
Schedule 1.
Kindly see, starting from Mouja Baltikuri, where it meets Howrah Municipal boundary, then it should be then, not then, along eastward, along the southern boundary of Bali municipality up to river Hooghly, in east from the water edge of the lowest tide of river Hooghly, west along with water edge of the lowest tide of northern bank of the point where it meets the eastern boundary of Mouja Podda of Sakrail police station, then north and northward along the western boundary of Mouja Goaberia and Mouja Thana Makua, then on the western side of Mouja Sultanpur and western side of western ward along the southern boundary of Unshani and Pulia, then along with the western and northwestern boundary of Pulia to its meeting point on the western.
One minute. যখন হিয়ারিং হবে কোনোদিন এইখানে আসবেন না, ঠিক আছে? কথা তো দূরের কথা, চুপচাপ বসুন ওখানে, একদম ডিস্টার্ব করবেন না হিয়ারিং এর সময়, পিন ড্রপ সাইলেন্স থাকবে। Yes, Mr. Bhattacharyya.
Yes, Pulia, then along the western and southern boundary of Pulia up to its meeting point with the western boundary of Mauja Ushnani, then towards then northward along the northern boundary of Mauja Ushnani up to Howrah Drainage Canal. Unshani, the Howrah Drainage Canal, then crossing the canal along the northern boundary of Mauja Unshani to up to its meeting point at Mauja Jagacha, then northward towards the western boundary of Mauja Jagacha and Mauja Dharsha up to its meeting point with Mauja Baltikuri, then from the Mauja Baltikuri and eastward along with the Mauja of Baltikuri up to the point where it meets Mauja Kona, then towards the western side of Mauja Kona up to its meeting point at Chakpara, then eastward along with northern side of Kona, then southwards along with the eastern boundary of Mauja Kona to the where it ends at Mauja Baltikuri, then eastward along with Mauja Baltikuri to the point where it meets Howrah Municipal Corporation. Therefore, the suit property is in Mauja.
ওইটা না, ওইটা দিন, কি বলে, পেপার বুকটা, পেপার বুক সেকেন্ড অ্যাপিলে পেপার বুকটা দেবেন।
Is in Mauja. একটু কোন মৌজা গো? Makra is not there. At page 10, kindly see the schedule, page 10 of the paper book. Kindly see the schedule, page 10.
মৌজা বাঁকড়া।
And next kindly see schedule 2. These are word wise of the corporation. There are 50 words, Milord. My junior has checked up. In none of these 50 words, Milord, Makra is there. None of these 50 words, Makra is there. This is one. Number 2, Milord, kindly takes up now Milord, kindly takes up section 1 of the 1956 Act.
বইটা একটু দিয়ে দিন। আচ্ছা, 1956
Premises Tenancy Act 1956.
1956, yes. দিন। ও
Both 97 Act and 1956 Act.
ওপরেরটা। Yes.
Both acts, 56 Act and 97 Act. Kindly see section 1. Kindly see, Milord, the short title, commencement and extent. 1. This act may be called the West Bengal Premises Tenancy Act 1956. It shall come into force on such day as the state government may by notification appoint.
This is a suit of 2000. So 1956 Act will prevail. Yes.
Yes, 17/1/72 application was filed. And it shall come into force on such date as the state government may do notification appoint. Then it extends to the whole of Calcutta and to the areas which have been or may thereafter be constituted municipalities under the provision of the West Bengal Municipal Act. Next, provided that the state government may by notification extend this part or any other part or any other area specified in the notification or may by notification exclude any part from the operation of this act or specified part thereof. My lord, the first of all, my lord, apart from this, my lord, there is no other, my lord, the extension of the act, my lord, the areas where it will, my lord, apply is there. My lord, I proceed on the basis that there is other my lord, notification by which state government may have extended, my lord, jurisdiction. My lord, that has not been produced either by the, my lord, from the side of the defendants who had raised this point or from the side of the court. One. Number two, kindly see, my lord, the 97 Act also.
No, we are not concerned with 97.
Very well. Not required. Then this is what, my lord, I wanted to, my lord, show. Now, my lord, regarding, my lord, the judgments. My lord would first, my lord, kind enough to see page 19 of the paper book.
Yes.
Kindly see the last paragraph. The record of rights and tax receipts is not at all cogent document to prove that the suit property is within the panchayat area and not within the municipal area. To fortify this, my lord, I have relied upon the schedule and the schedule 1 and schedule 2. It was, even if your lordship, my lord, thinks, my lord, by way of this panchayat tax receipt and municipal and, my lord, the record of rights, it cannot be proved, then, my lord, to fortify that, I have also relied upon the Howrah Municipal Corporation Act. One. Number two, that rent, that, my lord, the lordship knows, my lord, the record of rights, if it is finally published, my lord, unless it is rebutted, my lord, there is a, my lord, presumption of genuinity. It was never rebutted from the side of the, my lord, defendants. If your lordship would kind enough to note this. It was never rebutted. Genuinity of the document. It carries with it a rebuttable presumption. So long you do not rebut it, it is a genuine document. One. Number two, my lord, the tax receipt of the, my lord, plaintiff. It shows tax of the suit property were paid to a panchayat. Number three, there was a shalishi before the panchayat, and that document was exhibited from the side of the defendants. My lord has taken note of that on the last occasion. That was before the, my lord, names of both the parties are there, plaintiff and the defendant, the exhibit C of the defendant. My lord has taken note of that on the last occasion. That was exhibited without any objection from our part, that is on record. And court had also relied upon that. And that is, the first line starts with ভাড়া বাড়ানো সংক্রান্ত নিয়ে একটি সালিসি হয়েছিল, that I placed it on the last occasion. That is the beginning of that line. ভাড়া বাড়ানোর একটি, if, my lord, increase of rent, it must be between me and my tenant. Although, my lord, that is not a, my lord, authority to deal with fair rent, but being villagers, my lord, they went to the local pradhan. But they went to the pradhan, knowing fully well that the pradhan or that is the area is within the panchayat jurisdiction of the concerned panchayat. Now, my lord, kindly comes to, my lord, the another, my lord, page 20 of the paper book, appeal courts, my lord, this dangerous finding. Kindly see, my lord, the second last paragraph, hence in the issue at page 20.
Okay.
Page 20.
Page 20.
Here in this case, I find that the learned trial court at the time of disposal of the 1722A of the West Bengal Premises Tenancy Act as pleased to hold that the defendants are the premises tenant under the plaintiff in respect of the suit property, and the order was not challenged by way of the any of the parties before any higher forum. Therefore, the order passed by the learned trial court became final, and principle of res judicata applies, and also between two stages of the same litigation, to the extent that a court, whether the learned trial court or the higher court, having at the earlier stage decided a matter in one way or not, allow the parties to re-agitate the matter against the subsequent stage in the same proceeding. Therefore, he applies the Miller principles of res judicata. Since Miller the 1722A order Miller was not challenged by on behalf of the plaintiff before any higher forum. The judgment gulo না আরেকটা পাঠালাম যে এইটা, এটা কই কপি কই।
So the trial, first appellate court has relied upon the decision in 17.2.
Not even relied upon. He says that if he had relied upon, I could have understood. He says you did not challenge, that is res judicata. He doesn't even rely upon that.
Thereafter, he has stated that res judicata applies as such.
I have nothing to decide.
Nothing
A
to-
completely wrong approach. Yeah, kindly see page 10 of the judgment.
Paragraph 10.
95(1) CHN 395.
Paragraph 10.
Yes, my lord. The learned counsel of the defendant had audaciously claimed that that there is no default, since the petitioner had squared up all the payments within the time stipulated by the statute. But I am not unmindful of that the petitioner defendant can harvest the desired relief even at the stage of hearing of the issue under section 17(3) of the West Bengal Premises Tenancy Act 1956. It is the statutory duty of the court to find out from the record or from the documents as to whether the deposit as contemplated by the statute in respect of the payment of rent has been actually made. If the answer is found to be in affirmative, a court of law would be extremely slow to strike out the defense of the defendants against delivery of possession from the suit premises, for which no application is called for. The stage is yet to be over where the petitioner could put the document to dislodge the findings of the learned court below about the default found to have been committed since May 1989 to April 1994, totaling to a sum of rupees 3600. It is suggestive, therefore, the petitioner is crying before he is hurt. It looms large that the matters covering within the fold of section, kindly marks this line, 17(1) and 17(2)A are disposed of without any issue, which in my view cannot operate as res judicata. It is thus the statutory obligation of the court during the trial to find out the default, if any. It cannot appear as a res judicata. And court says, since you did not challenge it, therefore the findings remain, and the landlord-tenant relationship has been established. Therefore, the suit is not maintainable. Next line, there is no slender material on record of the learned trial court is passing the order overstepped its limits with the jurisdiction. The findings related to 17(2) applications are tentative and not conclusive. Therefore, during trial, he ought to have, Millard, decided this issue. Millard, there are two parts. The learned trial judge, Millard, has completely, the learned appellate court, with deepest of respect, had confused himself with, Millard, the issue of maintainability of the suit and the issue regarding, Millard, default of payment of rent and, Millard, landlord-tenant relationship. Millard had completely, Millard, confused himself. The issue of maintainability of the suit ought to have been decided on trial. Millard, in a 7(2) application or under the old act in a 7(2) application, what is decided? Millard, there are three things which are decided. One, is the Milord rate of rent, number 2 arrears of rent, and number 3 the landlord tenant relationship. Milord, these are 3 things which are decided. Milord, that does not endure, Milord, to the on the aspect of, Milord, to the maintainability of the suit. Milord, what are the consequences of Milord 7.2, Milord, or in the old Act 17.2, Milord, is given under section 17.3 of the Act, or in the new Act, Milord, under the 7.3 of the Act? What is that? Milord, defense against delivery of possession will be struck off. That has nothing to do with the maintainability of the suit. Therefore, there is a distinction. 7.2, suppose, Milord, a defendant fails to comply it. Order. Milord, there are 3, Milord, things in 7.10.1. Milord, he has to apply and, Milord, file within 1 month from the date of receipt of summons. If it is not, Milord, complied with, 7.3 applies. Then, Milord, suppose he does, then 7.2 has been filed, 7.2 arrears of rent decided, he does not, Milord, comply. Again, 7.3 applies. Then, Milord, his defense will be struck off. But still the court or the defendant will raise an issue of regarding the maintainability of the suit. Here, Milord, the defendant had raised the issue regarding maintainability of the suit. And what did the learned appellate court do? He said that 17.2a was not challenged. You have accepted what was decided in 17.2. 17.2, it was decided the landlord-tenant relationship is there. That's all. It did not touch upon the issue of maintainability. Whether it will fall within the Premises Tenancy Act or within the Transfer of Property Act, Milord, that was not decided. If I may place, Milord, the order of 17.2. Okay. Order.
ট্রায়াল কোর্টের রেকর্ডটা দিন, ট্রায়াল কোর্টের রেকর্ডটা। TSA, yes, TSA রেকর্ড। দিন, এটা কি এন্টায়ার ফাইলটা? না না না, TSটা শুধু এন্টায়ারটা দিন। এন্টায়ার থাকবে না, বুঝলেন? টাইটেল শুট আলাদা থাকবে, টাইটেল অ্যাপিল আলাদা থাকবে, থাকবে না। Filed order dated
102 dated 21st February 2008.
102.
102. Kindly see, on perusal of the record documents, I find that there is no document on record which is to prove that defendant actually paid rent during the period of August 1992 to February 2002. Therefore, it can be concluded that the defendant is defaulter in payment of rent from the August 1992 to February 2002. That is 115 months. The defendant is liable to pay ₹65 multiplied by 115 months equal to 7475 plus to rupees 622.91667, totaling amount payable being 8097.91667, rounding of 8098. The defendant should pay with the said amount, for 8 monthly installments of each. Equal installments of rupees 1000 each. First installment of rupees 1098. The defendant should deposit with the 15th day of each succeeding month. The first of that installment have to be paid by 15th day of next month. Current rent are to be deposited simultaneously. That the instant petition is disposed of accordingly. Where is the Milord res judicata maintainability of the suit? Even landlord tenant relationship was not decided. Only, Milord, this is only an order. Milord, the to Milord with the risk at the own risk of the Milord defendant, Milord, this was allowed to deposit. How can, Milord, this be an res judicata, Milord, in this suit? And Milord, 95(1) CHN, Milord, it is very clear, Milord, that is not conclusive, only a tentative finding. Well, this one, the next, Milord, is Milord, another judgment is, Milord, is, Milord, an application under 7.2 or 17.2 is maintainable. My lord would kind enough to, my lord, see the statute, 56 Act. Kindly see, my lord, section 17.1.
Yes.
Kindly see the opening language words. On a suit or proceeding be instituted by the landlord on any of the grounds in section 13, the tenant shall subject to the provision of subsection 2 within 1 month from the service of the summons to him, or where the appears to the suit or proceeding without the writ of summons, he shall enter appearance and file 17.2. Therefore, this has to be a proceeding under section 7. There has to be a proceeding, suit has to be filed on the grounds of section 13 of the Act. Well, what is section 13? Same as Milord section 6 of the new Act.
Grounds for eviction.
Grounds for eviction. Grounds for eviction. Now, Milord, two things. Apart from this, Milord, doubt was created in the mind of the Milord learned appellate court regarding the notice itself. That is another point which has gone against me. Now, Milord, what was the observation of the learned appellate court? Learned appellate court said that since you have given a notice for 30 days, therefore, the provisions of Premises Tenancy Act will apply. You were conscious that the suit property was in the municipal area and the Transfer of Property Act will not govern and the Premises Tenancy Act will govern. Milord, that is another point, Milord, which has gone against me. Milord, on the last occasion, Milord, my lord has taken note of that. I had relied upon the eviction notice. What did the notice say? 23rd August, Milord, 1998 or 99, Milord, what did the notice say? Notice said that
the end of the month of September.
Exactly. Therefore, that is a 30 days notice. Milord, I had relied upon.
You have referred
106.
106 of transfer of property.
Exactly.
15 days.
It should not go below 15
below
days.
15 days. You have stated
There is no bar in giving a notice above 15 days. But that does not automatically, Milord, treat that suit to be notice under section Milord 13.6 or under the present Act, Milord, section 6 for notice. I cannot go below 15. That is the cutoff date, cutoff, Milord, period.
And in the notice, there has not been any mention as regards to whether
TP Act or Premises Tenancy
Act or TP Act.
Exactly. Therefore, notice cannot be faulted on that way. Now, Milord, kindly, Milord, visualize another aspect of the matter. Kindly see what was the address given in the notice. It was addressed to the defendant. Milord, may I once, Milord, recapitulate your lordship's memory, Milord? It was, Milord, one of that, Milord, pink flags.
Yes.
Kindly see at the top. Where? Kindly see the address without where the defendant had received the notice. Because notice is not denied. Notice is although denied by them, but ultimately it has been proved that that
It has been received.
received an AD card is there. There was service of notice is Millard proved, and there is no cross objection against that finding.
Khalil.
Yes, original defendant. Original defendant.
Huh.
Therefore, may I kindly see what is the address, village and post office. Address of Khalil at the top. Therefore, admittedly in the village area, he has received the notice. Now, Millard, he cannot, Millard, say, Millard, it is in a municipal area. And Millard, Mauja Bankra is also there. Millard, this is Millard, the one judgment, Millard, I would be relying upon. It is the other one. Millard, kindly see, Millard, the
Mr. Bhattacharya, after the institution of this suit,
Millard,
has the area of the municipality extended?
Millard, let them show that. They are taking that
No,
part.
I'm asking.
As of
Recently,
now,
as of
Millard, I
now.
could not. That's why, Millard, I had to purchase a new book, Millard, to show that, Millard, it's not there.
Lordship, may I say upon?
No.
I am admitting that
But
this is on the.
You will get ample opportunity.
Yes, yes,
Very well. That is this
I
point.
am-
Then, Millard, 106 notice admitted. What remains? I should not waste your lordship's
Yes.
time. 106 notice admitted. What remains?
No, Lord Counsel, you continue your submission. As regards to the next authority, CO 1943.
Yes. Yes. Kindly see the third paragraph. The learned trial judge.
Hmm.
By the impugned order has permitted the defendants to comply with the provision of section 7(1) of the West Bengal Premises Tenancy Act 1997. Mr. Shaunak Bhattacharya, learned advocate appearing on behalf of the petitioner, submits that the plaintiff are seeking eviction of the defendants from the suit property on the ground of expiry of the 5 years after the death of the original tenant and his widow, and the defendants by operation of section 2G of the said Act of 97 have become trespassers in the suit property. Therefore, the suit not being a suit under section 6 of the Act of 1997, section 7 thereof has no manner of application. No manner of application. Well, this suit was filed for eviction of a trespasser. This relied judgment. Well, a suit for eviction of a trespasser is not a suit under the Premises Tenancy Act. It is a suit under the Transfer of Property Act or under the general law. Now, Millard, in such a suit, in similar circumstances, Millard, the defendant appeared and Millard filed an application under 7(2), 7(1) and 7(2). Court allowed that.
With the court in the revisional application, the Honorable Court has decided that it has not filed under section 6. So not.
This is also the same thing. This is not under section 13. Suit has been filed not under section 13. Therefore, Millard, the section 17(1)(2), even if it is allowed, Millard, I could not challenge a point of res judicata. On the last occasion, I have shown Millard 105 of the Civil Procedure Code. Millard, now Millard in the second appellate stage, Millard, I am impugning that. If I may again, Millard, recollect your lordship's memory, CPC now. Kindly see, Millard, 105 of the Civil Procedure Code once.
Yes.
Kindly see, Millard, 1, subsection 1. Save and except otherwise applied, no appeal shall lie from any order or by a court in exercise of its original or appellate jurisdiction. But when a decree is appealed from or error or defect, irregularity in order to affecting the decision of the case Well, this is affecting the decision of the court, may set forth as a ground of objection in the memorandum of appeal. Now, my lord, on the last occasion, when I placed this, my lord, provision, my lord has my lord asked the question to me, why didn't you, my lord, why didn't you take this as a ground in the first appeal? My lord, on that day, my lord, I could not answer. My lord, the appeal was not filed by me. Appeal was filed by the defendant. Therefore, I did not have, my lord, the option to raise this, my lord, during the first appellate stage. One. Number two, this was not an issue which, my lord, my lord, has gone into by the learned trial judge. Therefore, I did not have the issue, my lord, to raise this, my lord, in the first appellate court. I have only, my lord, the option to raise this before the second appellate court. That is, your lordship. The last, my lord, the judgment, my lord. Kindly comes to page, the para 10 at page 11. Decision with reasons. Page 11, my lord, para 10. This court delves into the issue regarding including the substantial question of law. So long as the provision of rent control acts are not made applicable to a particular area, the rights and obligation of the landlord and tenant are to be governed by the provision of the Transfer of Property Act. Now, my lord, my learned friend, my lord, just now said that he admits that, my lord, the Premises Tenancy Act doesn't apply, only the Transfer of Property Act applies. Well, he admits that this is a panchayat area. If that be so, my lord has already, my lord, decided the issue. The Transfer of Property Act will apply. In this regard, section 1, subsection 3 of the West Bengal Premises Tenancy Act 97 is laid down. The said provision is stated as follows. My lord, that was a case of 97 Act. My lord, we are in 56 Act. As the sued property is situated within the panchayat area and not within the municipal area, so as to present lease is to be guided by the provision of Transfer of Property Act, and the said transfer of interest is lease. As regards to the schedule of the plaintiff has in detail stated about the demarcation of the suit property. That is one room. It has been stated that the respondent plaintiff, the said room is butted and bounded by the north by Shuri Katwa Paka Road on the north. And, my lord, those are on the facts of those cases. Ultimately, my lord, the first two paragraphs are, my lord, related. My lord, is the deciding factor. There,
Sir, my lord. May I start, my lord?
Yes.
I am the happiest person. Rather, the respondents are the happiest person to say that this food property is situated within the panchayat area and governed by the Transfer of Property Act to save me from the menace of section 2G of the Act. Now, my lord, the journey of the suit in the court below started with the serving of the eviction notice, therefore rectification notice and plaint. We filed a written statement. Now, my lord, I am hearing cautiously. I am looking out whether one point that plaint is the plaint of the suit. Now, my lord, you have framed plaint under which provision of the law? Plaint either under West Bengal Premises Tenancy Act 1956 or under the Transfer of Property Act. If you say that suit property is within panchayat area governed by Transfer of Property Act for the grounds as enumerated under section 111 of the Transfer of Property Act or not. My lord, in My lord, in exhibit 3, that is the notice, and exhibit 4, that is the rectification letter for rectification of the notice earlier issued, my lord.
Yes.
My lord,
Notice.
my lord will find that section 30 days notice has been given. That is the one of the point of argument, that as per the Act of 1956, 30 days notice, he is saying that section transfer of property act prescribed 15 days, so I have given the much longer time. No, but my lord, in the eviction notice, the grounds taken are the default in payment of rent, ground of reasonable requirement. That ground of reasonable requirement is not available under Transfer of Property Act.
Yes.
Lordship, in paragraph 3 of the notice, I am reading it out, that my aforesaid client several times requested you for the rent, but you have failed and neglected to pay the monthly rent to my client. Moreover, you have causing damages the said room, as such you are liable to be evicted. The said room is reasonably required by my said client for his own use and occupation, and also for building and rebuilding. The building and rebuilding is also not available. As such, you are liable to be evicted, my lord. Now, my lord, I will straightforward, I will come to the plaint, my lord. Plaint, my lord. Plaint, my lord.
Yes.
Plaint, paragraph number 4, my lord. Paragraph, that the plaintiff reasonably requires the suit premises for his own use and occupation. The plaintiff has to run a medical shop at the suit building, and he immediately require a room for his godown purpose, as well to keep freezer, cooler, and other machines to preserve valuable medicines. And for the said reason, the room is required urgently. The plaintiff has to make the room to a new for the said purpose, and is essential for building and rebuilding purposes, and until and unless the defendant be evicted, the plaintiff shall not start for the building and rebuilding the old structure. Now, my lord, in this schedule, all that piece and parcel of one paka room on the ground floor, comprised in Dag number 511 under Khatia number 735 of Mauja blank. Now, my lord,
Moja Bakra.
might be in the copy some nothing, that is not the point. Now, my lord, during the proceeding of the suit, one point elaborately argued that defendant filed application under section 17(1) and 2 for the deposit of the area of rent and subsequent rent month by month. That is admitted, that I have paid. Now, my lord, during the proceeding of the suit, they have filed one application under Order 39 Rule 7 for local inspection to establish the ground of reasonable requirement. That has been rejected. What I want to impress before lordship, that they have framed the notice, framed the suit, everything under the provision of West Bengal Premises Tenancy Act 1956. If you are saying that suit is governed by Transfer of Property Act, then plaint, notice, all are misconceived, not maintainable, because you have not preferred the suit under Transfer of Property Act.
Why the Order 39 Rule 7 was rejected?
Rejected, my lord. Actually, I was not in trial court. They rejected on the ground that it has been filed on the later stage. What I gathered from the paper book, my lord.
But
From-
it is there state
from the
notice
proceeding.
they are in the appellate court observation, and there since it has been filed at the argument stage, court has simplicity rejected it on the ground.
Trial court rejected. So, my lord, this ground of reasonable requirement taken, it shows that you have framed your suit under the West Bengal Premises Act 1956, for which your suit is not maintainable. For the argument you said that the suit property is situated within the Panchayat area governed under Transfer of Property Act. Now, my lord, when during the hearing of the 17(1)(2) application for determination of area of the rent, this plaintiff did not adduce any evidence. They accepted it. They accepted it with a, what should I say, that the suit is running under West Bengal Premises Tenancy Act. In case this is not the suit under Transfer of Property Act, you should have adduced the evidence. You have should contested that application, but you did not. You allowed that one. Let it be allowed. And that order is still today unchallenged, my lord. Unchallenged today, till today, my lord. So, therefore, my argument before lordship is that when you started the journey of the suit since the issuance of the notice and filing of the plaint with preconceived idea of that you are proceeding under the West Bengal Premises Tenancy Act 1956. Now, on the later stage, you are saying the transfer of property, then you are arguing for that your suit was not maintainable in the court below, my lord. You are arguing for your suit is not maintainable. He should have taken the liberty to withdraw the suit and file a suit under the Transfer of Property Act. But all along you have proceeded under the Act of 1956, my lord. Now, my lord, my second avenue of argument is, second point of argument is,
Yes.
ground of eviction, either under Transfer of Property Act or 56 Act, they have only one, because there is no written agreement that I have broken any terms and condition, but or the lease expired by the efflux of the time. Only one ground that is that default. Now, my lord, for the sake of argument, said that my application has been decided under section 17(1) and 2. Now they are saying that it is wrong without challenging for so many years. I have deposited the rent. Objective of the 17(1) and 17(2) is you have to apply before the court to determine the area of rent, and you have to deposit it. My lord, let me assuming that my application is under wrong provision of that, but I have deposited the rent. It may be considered under section 114 of the Transfer of Property Act. Section 114 of the Transfer of Property. Section 114 of the Transfer of Property Act.
TP Act. Transfer of Property Act.
Section
ওইটা কি ওই যে সেকেন্ডটা ওইটা তলা ওটা yes
Section 114 of the Transfer of Property Act, relief against forfeiture for non-payment of rent, where a lease of immovable property has determined by forfeiture for non-payment of rent, and the lessor sues to eject the lessee. If at the hearing of the suit, the lessee pays or tenders to the lessor the rent in arrear, together with interest thereon and is full cost of the suit, or give such security as the court think fit sufficient for making such payment within 15 days. The court may, in lieu of making a degree for ejectment, pass an order relieving the lease against the forfeiture, and thereupon the lease shall hold the property lease as if the forfeiture had not occurred. My lord, what I want to impress that the objective of payment of arrears of rent and payment of subsequent rent I have made. Maybe the order has been passed under section 13 of the Act. I may be considered as a deposit of rent under section 114. Except this ground of default, they could not have established any other ground as enumerated under section 111 of the Transfer of Property Act. Now, my lord, I will cite 5 judgment, very short judgment, and I will conclude my argument. David. My lord, first one is (1966) My lord, 1966 Supreme Court 1061, first one, my lord. Decision of the court having jurisdiction, even if wrong, is binding between parties till it is set aside. A wrong decision by a court having jurisdiction is as much binding between the parties as a right one, and may be superseded only by appeals to higher tribunals or other procedures like review, which the law provides. Now, my lord, the decision passed by this our Home High Court in MAT 1898 of 2025, second page, my lord. Second page, my lord, para 4, last 3 line. The order of the coordinate bench, in absence of challenge, has attained the finality.
This is the submission of the learned counsel.
My lord,
This is the submission of the learned counsel.
maybe my Supreme Court earlier cited that will be serve the purpose.
Would
Now
you like to furnish this one?
Yes, ma'am.
This was a submission of the learned counsel.
Okay, I'm taking that. Earlier decision will serve the purpose. Now, my lord, last one point of argument is that, my lord, if appeal is the continuation of the suit, if the appellate court even can order under section 114 if there is a deposit not in accordance with the law in the appellate court. Here, I will cite, my lord, 1969 Supreme Court 1349, my lord. Lordship got the second page, my lord. Second page, into para A. Head note A, para second. In terms, section 114 makes payment of rent at the hearing of the suit in ejectment a condition of the exercise of the court's jurisdiction, but an appeal being a rehearing of the suit in appropriate cases. It is open to the appellate court at the hearing of the appeal to relieve the tenant in default against forfeiture, passing of a degree in ejectment against the tenant by the court of first instance does not take away the jurisdiction of the appellate court to grant equitable relief. Failure of the tenants to avail themselves of the opportunity does not operate as a bar to the jurisdiction of the appellate court. The appellate court may, having regard to the conduct of the tenant, decline to exercise its discretion to grant him relief as against forfeiture. The question is not one of the jurisdiction but of discretion. Relief against forfeiture of tenancy for non-payment of rent, discretion used in favor of tenants by the lower appellate court, appeal by the special leave, ordinary Supreme. Now, my lord, this my conduct is that I always ready to pay the rent. I have paid the rent in the trial court, and that is still it has not been withdrawn. Next, my lord.
Not been withdrawn.
No, my lord.
Not withdrawn.
No.
The landlord has not taken the money, received the money.
No, I have not taken the money. What he has done, I do not know, my lord. And
No,
till today,
the question from this end is whether the landlord has accepted the rent or not.
Accepted the rent or not, my duty, my responsibility is to comply with the order of the court. I have deposited in the name of the landlord in the court through challan. Landlord is aware of that. They did not object it till that I'm not objecting. Even they did not adduce the evidence to obstruct my application under section 13, my lord, till today. Now, my lord, AIR 1953, Bombay 129. Head note D, my lord. First page. 152, 129, sorry. Forfeiture, meaning of plea under section 114, first time in second appeal. Section 140 TP Act gives jurisdiction to court to grant relief to the tenant against forfeiture for non-payment of rent, and there can be no doubt that this power can be exercised even by the appellate court. But the word forfeiture used in section 114 has a technical meaning which must be ascertained by reference to section 111G of the said act. Forfeiture in this technical sense is incurred in the case the lessee breaks an express condition which may re-enter, and even in such a case the lessor has to give notice in writing to the lessee of his intention to determining the lease. In proceeding against the subtenant where the lessee was not on record and plea under section was not made in court below, the High Court will not enter the plea for the first time in second through the plea raises a mixed question of fact and law. My lord, what I want to say that I have paid the rent. I have not made any defaulter. Their suit is misconceived on the ground that they proceeded under section Act of 1956, contradicting their establishing that the suit is governed by the Transfer of Property Act. By their argument, they established that the suit in the court below is not maintainable. That's all.
You are not relying upon 1987 Supreme Court.
1987, it is well settled, my lord. It is well settled that the decision given 1145. A case, it is well settled that the decision given by a court at an earlier stage of a case is binding at a later stage through interlocutory judgment or opinion. That's all, my lord.
My lord, very short submission in reply. Kindly, my lord, what was the submission? My learned friend had relied upon 114. Say that this application be treated as, my lord, irrespective of the, my lord, caption of the application, this may be treated as, my lord, 114. Now, my lord, whether this can be, my lord, treated as, my lord, section 114 application, my lord, kindly see, my lord, page 4 of the paper book. Kindly see the last paragraph. As per the defendant counsel, he states the predecessor and was tenant in the suit property. The rent was enhanced. The rent was paid throughout. The petition under 7.1 of the rent has been paid. Court challans have been filed. Therefore, the defendant is defaulter since 1991 is denied and false. Therefore, they have taken this as this application under Milord Section 7.1 of the Act or 17.1 of the Act, and there is no approbate and reprobate at the appellate stage. One. Number two, kindly Milord takes up page 14 of the Act, of the paper book. There is no approbate and reprobate. Kindly see Milord page 14 of the paper book. Kindly see Milord the very first Milord, the second paragraph, case of the defendant appellant. Kindly see Milord the first paragraph. 140, the fourth line, thereafter the shop room was transferred to Qasim Khan and the defendant used to pay rent under the defendant denied that he is a defaulter. Next 3 words. And he filed separate petition under section 17.2 of the West Bengal Premises Tenancy Act. Therefore, Milord, now Milord, my learned friend Milord cannot say that that is an application under section 114. No, cannot. Your specific case is that of 17.2, which Milord I have relied upon, unless that is a Milord one unreported case, Milord, unless it is Milord a suit under clauses of section 13, Milord, it cannot be. Now Milord kindly takes up Milord the judgment. Milord 61, 87 and 89 Supreme Court, my learned friend has not relied upon. 66 and 87 Supreme Court. 66 Supreme Court and 87 Supreme Court are on the same point of res judicata and binding precedent. These two are on the same point. Well, let me deal with Milord one by one. Kindly see Milord 66 Supreme Court 1061 paragraph 14. Kindly see Milord. Before proceeding with the argument in detail, we can dispose of the second contention very shortly. The argument proceeded on a fundamental misconception as it seeks to equate an incorrect decision with a decision rendered without jurisdiction. Milord, when a wrong decision by a court having jurisdiction is as much as binding upon the parties as a right one, and may be superseded only by appeals to higher tribunals or by procedure like review review with law provides. The learned judges of the High Court who rendered the decision on 4th of May 1952 had ample jurisdiction to decide the case on the fact, and the decision was on merits erroneous. Therefore, Milord, I have an alternative, Milord, two alternative argument. Milord, my learned friend was not there. Milord, on the last occasion, Milord, I was saying, Milord, judgments may be of two types. One, which court has jurisdiction but factually incorrect. But one, Milord, the court, Milord, has no jurisdiction but passes the order. With respect to the first, Milord, the prior, Milord, the category, where the court has jurisdiction but factually incorrect, definitely it has to be challenged on the ground of res judicata. Definitely, yes. Where, Milord, where I say where the court otherwise has no jurisdiction, then it is nullity. It is nullity for all purposes. That is the purpose, Milord, of Milord referring to that judgment of Justice Biswajit Basu. হ্যাঁ ও বলছে নাকি এটা 72 ফেল করে বলছে 114 তা আমি সেকশন 106 এ শুট করে 114 দিয়ে কি করব যার জন্য জুরিসডিকশন তো না না হয়ে গেছে
Yes.
Now, my lord, suppose, my lord, I proceed, my lord is not satisfied with my this argument. My lord is of the view that yes, res judicata applies since since the interlocutory order was not challenged under 17(2). In that case, my lord, 100 section 105 is my remedy. I can affecting the merits of the suit, merits of the case, that can be, my lord, taken as a ground of set forth in the memorandum of appeal. That is exactly the language in civil procedure code. That can be challenged as a ground in the memorandum of appeal. That is the answer. Therefore, my lord, these two, my lord, judgments, my lord, takes care of that. Then, my lord, 69 Supreme Court, 1394 and 53 Bombay, these two are, my lord, 114. These two are 114. One says that if 114, both the judgments are on the same tune, my lord, what I have, my lord, read. Same thing, my lord, it says that the appellate court have the ample jurisdiction to allow to dismiss a suit and to allow them to deposit the admitted arrears of rent, and on that, on the ground of forfeiture of lease, my lord, the suit will, my lord, not be decreed. My lord, first of all, this is not a suit, my lord, filed for forfeiture of lease. My lord, kindly see, my lord, that is the language. My learned friend had placed it before your lordship. It has to be in case of a forfeiture of lease.
Yes.
Where a lease of immovable property has been determined by forfeiture of non-payment of rent. Where there was no written lease, my lord, here. This is only a, my lord, simpliciter, my lord, tenancy matter, where the landlord-tenant relationship is otherwise, my lord, admitted. Therefore, my lord, how far 114 applies here, my lord will, my lord, kindly decide. And when their learned counsel, both before the trial court and the first appellate court, has taken this application, my lord, admission has taken this application as an application under section 17(2). One. Number two, my learned friend has not made any submission regarding, my lord, the whether it falls on the panchayat area or, my lord, the municipal area.
No, that he has admitted.
Then, my lord,
Within the
I
panchayat area.
again, my lord, rely upon my lord's judgment, paragraph 10.
No, you have cited that one.
Yes, my lord, paragraph 10, my lord, at page 11. If that be the case, my lord is very specific. So long as the provision of rent control acts are not made applicable to a particular area, the right and obligation of the landlord are to be governed by the provision of Transfer of Property Act. In this regard, section 1(3) of the Premises Tenancy Act is laid down. Therefore, this is the answer. One. Number two, my lord, my learned friend has relied up, my lord, had tried to find fault in the notice.
Notice and plaint, that is the grounds of eviction.
Lordship would kind enough to, my lord, kindly, my lord, appreciate whether, my lord, giving notice, my lord, is at all necessary. In case, my lord, instituted on the basis of, my lord, 106, section 106 of the Transfer of Property Act. My lord, that was, my lord, notice was given. My lord, there are line of judgments, my lord, which says the notice in 106 Act, only filing of suit itself is notice. Where notice given, not given is immaterial. Suppose, my lord, this would have been a straight away suit have been filed, my lord, without giving notice. Then, although this is not the case here, But even my lord, in a 106 my lord, case, my lord, notice is immaterial. Filing of suit itself is termination.
Another point he has agitated that all the grounds have been laid down under section 13 of the West Bengal Premises Tenancy Act. Relying upon those grounds, eviction has been sought for.
Eviction has been sought for.
So
But
this
Premises Tenancy Act.
Premises Tenancy.
For that, my lord, that's why, my lord, I place, my lord, the jurisdiction of the, my lord, Corporation Act and, my lord, 1(3). My lord, even if I, my lord, have write those grounds, Act does not apply there. I have only, my lord, sought for your eviction. It is the court to decide, or anyone who is objecting to the jurisdiction of the court to bring forward, no, this falls within the jurisdiction. What evidence did they lead? What documents did they come forward before the court? Only because I have, my lord, said it is the grounds have been laid down. That's why they have to, my lord, bring out some, my lord, documents before the court. No, this is not there. Then what about exhibit, my lord, the two series, Khajna document, rent receipts? Application of the act has to be there. Na reply for a reply.
You have raised in new points.
No, you were not there on the last
Is
occasion.
he has not raised any new point.
The court has no jurisdiction in the court below.
This
Act does not apply.
He's raised,
What
he
is
was
the-
not here.
Oh, my lord, I am my lord.
Nil.
Act does not apply. I am
Uh,
first I am here.
The learned counsel representing the appellants, appellant, um, further commences his submission and concludes the same, and in support of his contention, commences his submission and concludes the same. In support of his contention, he has relied upon he has relied upon an order passed in CO 1943 of 2001, passed by a coordinate bench of this court. Full stop. He has also relied upon a judgment published in 1995, 1 CHN 395, 1995. Upon the judgment published in 1995, Volume 1 CHN 395, and has relied upon a judgment passed in SA 33 of 2017 by coordinate single bench. Full stop. The learned counsel representing the respondent submits exhaustively and concludes in support of his contention. He has relied upon the following authorities: Act number 1960 AIR 1966, Supreme Court 1061, তারপরে দিন AIR 1969, Supreme Court 1349, তারপরে দিন AIR 1987, Supreme Court 1145, and AIR 1953, Bombay, page 129. Argument is completed. Reserved for judgment.
Grateful, my lord.
ওয়াশরুমটা ঘুরে আসি, বুঝলেন? ওয়াশরুমটা একবার ঘুরে আসি। রিবো
Sure, ma'am. Sure. ওখানে এটা আমার কপি
Step number 2.
My lord, so taking cue from yesterday's argument, my lord, I, my lord, submitted that the suit is firstly barred by limitation. Because in view of the prayer A, where the plaintiff sought for declaration and cancellation of two deeds, firstly executed in 2015 from the legal heirs of Gunodhar to the vendor of the present petitioner, Biren Hathi, and secondly in 23 from Biren Hathi to my client in favor of my client. So 2015 and 2023, lapse of 8 years. Article 56, my lord, part 3 of the Limitation Act
3
96,
years.
my lord, that to declare the forgery of an instrument issued or registered when the issue or registration becomes known to the plaintiff. They alleges that by forging or by misdeclaring that Gunodhar was the sole legal heirs of Annoda Prasad Dhali, by falsely or fraudulently claiming themselves as the sole owner in respect of 0.8 decimals of land, they transferred the property in favor of Biren Hathi, the legal heirs of Gunodhar. So, and by that said transfer, in that said deed, there were wherein the husband of the present plaintiff was figuring as an witness. So the limitation is 3 years. To declare the forgery or instrument issued or registered, 3 years. 59 also says suit relating to decree and instrument to cancel or set aside an instrument or decree for the rescission of a contract.
Mr. Poddar, the husband of one of the
Plaintiff number one.
Plaintiff
Number one.
Plaintiff number one is a witness to which deed?
2015, first deed.
First deed.
Yes. So my client at that is his name is, my lord, Ajit Bachar. Kindly see the description from the plaintiff number one.
He is the respondent number. Opposite party.
Mridula Bachar. Huh, my lord? Yes, opposite party.
One. Srimati Midula Bachar.
Mridula Bachar. So Mridula Bachar, Lavani Roy, Siddip Bachar, all the legal heirs of Ajit Bachar are figuring as plaintiff. My lord, say none other than this Ajit Bachar's family members. So the plaintiff's head of the family, deceased Ajit Bachar, participated in 2015 deed wherein the legal heirs of Gunodhar transferred first the 0.8 decimals of land here in C schedule property. So knowledge, participation, everything is in 2015 about the transfer of the 0.8 decimals of Schedule C land. So under the law, anyone wants to have a declaration from a competent court of law or to praying for cancellation of any valid registered instrument, he should come before the court within 3 years from the date of registration of the instrument. So my first contention, the suit is barred by Limitation Act. Number 2, suit is barred by the law of estoppel, waiver and acquiescence. Suit is barred because under section 34 of Specific Relief Act.
Yes.
And suit is barred for misjoinder of parties wherein as pro forma defendant in the suit, local clubs, secretary, president, villagers, all are in the array of a suit for partition. So we know the partition between the co-owners, no third party stranger have any right to stay or to be made as party. Partition suit which amongst the co-owners only, no third party. And declaration also paying for cancellation of deed, that too also by any co-owner or the party whose interest has been hampered. And suit is by wrong person and a wrong intention. Collusive suit, because no written statement other than my client's written statement. Here, partition suit ought to have all the other co-owners will join by filing a joint written statement excepting myself, because I am the new incumbent. I have purchased someone's right. Here, my lord, no written statement. Completely collusive suit for the interest of third party who happens to be not the legal heirs of Annoda Prasad Jhali. On those aspects, I will refer some judgment, 3 judgment on those aspects. Framework is this. Two 2006. Let first come to this judgment, 2006, volume 3, Supreme Court cases, page 312. This is, my lord, with regard to when the court is passing an order of status quo without interpreting it in its true sense. In what sense the parties will maintain status quo? In what form? In respect of which property? How? Civil Procedure Code.
Which paragraph you are referring?
Paragraph 5, my lord.
5.
In short, my lord, kindly let me go through the head notes. Order 30, Rule 1 and 2. Order 43, Rule 1 are ex parte, ad interim order of injunction, mode of passing of, refusal by trial court to pass such order. Here, ad interim order was refused. Appeal against passing of direction by appellate court to maintain status quo in respect of the suit premises without indicating what the status quo was. Here, my lord, kindly remember, in the final injunction order, injuncted me, they saying that further construction in respect of entire C schedule property, entire word was used. That means the property, C schedule property, is a vacant one. For that reason, I am relying on this judgment that says the indicating what the status quo was, it must be contradictory. And here, my lord, there is a contradiction. There is a contradiction. Propriety of held was not proper. The said order should not have been passed in such a manner at the initial stage of litigation, particularly where appellate court was dealing with only limited question of grant of injunction and the main application of injunction pending suit was still pending before the trial court. My lord, here, my lord, contradiction in my lord, contested, my lord, judgment, contested order of injunction. It is not adding.
Temporary injunction.
Yes, temporary injunction, my lord. Now, my lord, kindly come to paragraph 5. It is necessary, my lord, got it, my lord, paragraph 5.
You are referring to uh, uh, third line.
My lord.
It was not approved.
Yes. It is necessary to notice at this stage that in an original suit of this nature, it was not appropriate for the additional district judge to pass an order directing the parties to maintain status quo without indicating what the status quo was. It was if he was satisfied that the appellant before him had made out a prima facie case for an ad interim ex parte injunction and the balance of convenience justified the grant of such an injunction, it was for him to have passed such an order of injunction, but simply directing the parties to maintain status quo without indicating what status quo was is not an order that should be passed at the initial stage of a litigation, especially when one court had found no reason to grant an ex parte order of injunction and the appellate court was dealing with only the limited question whether ad interim order of injunction should or should not have been granted by the trial court, since the appeal was only against the refusal of ad interim. My lord, here, my lord, granting refusal of ad interim ex parte order of injunction and the main application for injunction pending suit was still pending before the trial court itself. Therefore, we are prima facie of the view that the additional district judge ought not to have passed an equivocal order like the one passed in the circumstances of the case. But of course, the aspect of has relevance only to the extent that that before ordering an interim mandatory injunction or refusing it, the court has first to consider whether plaintiff has proved that he was in possession on that suit or on that date of the suit. Here, no possession on the date of the order and he had been dispossessed the next day, unless a clear prima facie finding that the plaintiff was in possession on those date is entered, an order of interim mandatory injunction could not have been passed and any such order passed would be without jurisdiction. An interim mandatory injunction is not remedy that is easily granted. It is an order that
Herein mandatory injunction was
yes,
granted.
here mandatory. So, my lord, what court says, what the apex court suggested, that while granting order of status quo, it should be clear and clear from the side of the court after being satisfied that plaintiff has made out a good prima facie case. Here, my lord, if your lordships compare the ad interim order and final order, there is a gulf difference. Ad interim order, status quo, temporary injunction disposal, further construction for in respect of entire schedule of land. So, when, my lord, the plaint case, there was a two-story building covering 0.08 decimals of land. So, in final disposal, temporary injunction disposal, the result is, my lord, direction is, my lord, no further construction, no new further construction over entire. So those two things are different. And moreover, when a suit of this nature, when, my lord, in temporary injunction, it was discussed that 2015 did, 2023 did, knowledge of the plaintiff or plaintiff's family member. By when this fact was there, so, my lord, by, my lord, ignoring the said fact, which is admitted position, because which are figuring in the first relief, first prayer. So court can't ignore that when the suit was filed, knowledge was there, it was pleaded during the final hearing of the temporary injunction. So by ignoring the defendant's contention about the prayer, the court, my lord, passed an order which is a material irregularity, total illegality. The plaintiff should come up with clean hands. We know to have to pray for any injunction in his favor. What is the clean hand? How they will suffer? Status quo? All right, status quo by both parties. So no new construction when there is a construction. So this is a vague order. Vague because it is self-contradictory. If your lordships compare, may I refer once again that
Which one?
temporary ex parte injunction and temporary injunction, that portion.
No, need not. No, I'm searching about the written objection. Written objection to the order 39 rule 1 and 2.
Yes, that is in the plain in the petition. That is page, my lord. (45) is the application for temporary injunction.
Page 72, my lord.
Points, once again, learned counsel,
My lord.
the points which you are agitating now have all been raised in the written objection?
Yes, written objection is there.
No. Written objection is there. Have you raised these points in the written objection? Your fact has been stated in page 81, paragraph 30. Paragraph 30.
Black color page.
There is reflection in the judgment that my counterpart in the court below agitated those points, and reflection in the judgment itself. So, my lord, the learned judge, my lord, should not, my lord, ignore the very and vital point that the 2015 did and shoot of 2023. It is not a shoot for the partition itself, simpliciter, but a shoot for cancellation of those two deeds. And it is also evident, my lord, when my client got the opportunity to file written statement to contest the injunction application, none other co-sharer, they are not figured. I doubt that if the present suit before the court below has been at all filed by Midula Bachar, or her name is only used
No, you
for
have-
some mischievous purpose.
you have
Because I draw your lordship's kind attention.
raised the issue of
Yes.
collusion.
Yes. Because from the gist of the plaint is to certify the stranger person who is figuring as performer respondent,
That you have
their possession just to have a court seal.
yesterday you have mentioned in detail.
Main object. Otherwise, that say 1955 on the diet, 2000 and prior to 2015, everything has been done by
Each and everything can be accepted except 1955 what you are mentioning about the death
That
of
Annoda. Though my client was not specific,
verbal submission won't suffice.
though my client was not specific, but denied it.
Ought to have raised
Yes.
at that point.
Yes.
Now you cannot raise.
My lord.
Now you cannot raise that. You can raise the other issues, not that one. Yes. Next citation.
My lord, paragraph 7 once, my lord.
5 and 7.
Admittedly, the defendants are the owners of the building. The plaintiff, my lord, kindly consider, my lord, the demeanor of my client. My client, when went to purchase the property, scheduled property in 2023, my lord, examined the title of his vendor through 2015 deeds. He find that 2015 his vendor purchase 8 year elapsed. There was no problem. So Bidenhati was in possession, and he also, with the execution of the instrument, simultaneously handed over the possession. What more a purchaser will do? What more? No problem come forward, no dispute had ever raised by the present plaintiff or other than my clients, other defendant, opposite party before your lordships here. So he safely purchased it. No problem. No, and this fact, this purchase, this transfer by the heirs of ki bachar ওর নাম? Heirs of
Ajit Bachar.
Gunodhar.
আচ্ছা।
Gunodhar's Bachar's heirs transferred it. Known to everyone, because they are all residing from the cost title, you will also find it. All the address of the other co-owners are nearby. So it is known to everyone, no dispute. So he purchased it. And now he faced it. There was some dispute with club. Club, my lord, demanded hefty donation. That is the behind the curtain.
No,
Behind the curtain,
we won't
this
go,
dispute.
we won't go.
We
behind
want
the
to
curtain.
travel, but
No, because
but everything has some
Yes.
objectivity. Every action has some objectivity.
we will have to be confined within the
My lord,
purview of.
So paragraph 7. Admittedly, the defendants are owners of the building. The plaintiff was setting up a case that the plain schedule part of the building. Here, my lord, excluding my lord B. They are very interested to exclude B. My lord, kindly see. The plaintiff was setting up a case that the plain schedule part of the building had been granted to him on lease on 17th April 1998, and that he had obtained possession thereof on the basis of such a lease transaction. The lease thus, my lord, here story is something different, my lord.
So
Skip
why
it,
you are placing? You are relying upon paragraph 5.
my lord. And my lord, in comparing two judgment, ad interim and the temporary injunction, final judgment, that there is a difference, and ignoring the very facts of limitation that which is reflected in the order itself. The illegality grows there.
What is the difference?
Difference,
The order passed in the during ad
Yes.
interim temporary injunction and
yes,
temporary injunction.
it simpliciter a status quo, my lord.
Was granted during the ad interim temporary injunction.
Yes.
In which page number?
Yes. I'm coming.
It is not provided, I think.
page, my lord, here. 102, 103, these are the record of rights, 104, 105. 100 with the miss happy. No, not 105, not 105. It is a miss appeal.
You were referring to the order passed
But
at the ad interim stage.
at interim stage,
That I don't think it has been annexed.
yes.
Page 69.
Annexed.
Both parties ordered.
Order dated 4th of April 2020.
Both parties, plaintiff and the defendant number 1 and 2 are directed here, plaintiff and defendant are directed, defendant number 1 and 2 are directed to maintain
Maintain status quo in respect of nature,
character and position,
condition.
see schedule property till 1904.
Hmm.
Yes, and my lord, on 20th September 2024.
In addition to that, you have been restrained from constructing.
Yes. And my lord, constructing by saying what? That the application under Order 13 Rule 1 and 2 reduce that it is not with you, your lordship, my lord, because my lord, my learned friend help ওটা দাও তো
কালকে জেরক্স করেননি?
না ওটা করা হয়েছে।
It was asked to be provided not yesterday, day before yesterday. Provide the copy of the.
My lord, few lines.
Yes, senior counsel, you cannot say such thing, learned counsel. It is not expected.
That the application under Order 13 Rule 1 and 2 reduced section 151 of the Code of Civil Procedure dated 4th April 2023 filed by the plaintiff is hereby allowed on contest against the defendant number 1 and 2 but without any order as to cost. Both parties and defendant number 1 and 2 are hereby directed to maintain status quo in respect of the nature, character, position of the Schedule C mentioned suit property till disposal of the suit. The order dated 4th later is hereby made absolute till disposal. The application.
Wherein you have been restrained.
No. My lord, I'm sorry. From appellate court. Appellate court
Mr. Poddar,
added something more.
provide a copy of this one. You shall have to provide.
My lord, 69, page 69. No, page 69.
এটা দিয়ে দিন.
And the order impugned.
Order impugned is that the miscellaneous.
Yes. He gone further. Third paragraph of page 2, inner page 2 of the judgment. On the other hand, appellants being the defendant number 1 and 2 made out a case in their defense. Gunodhar being sole legal heirs became absolute owner of the property after death of another Prasad. The name of Gunodhar was recorded in ROR in respect of the suit property. It is further case of the appellant that the legal heirs of Gunodhar sold the property in 2015 to one Birenhati and present appellants purchased the property from said Birenhati. Defendant number 3, therefore, the respondent plaintiff are not co-sharer. It was our case, not co-sharer of the suit property and shall have no right of partition. This property is not partible. In the impugned order, the learned court below observed that nothing is revealed as to exclusive ownership of Gunodhar Dhali in this scheduled property, and it is not previously found that property has been partitioned by
Herein also where you have been restrained? In the misappeal also you have not been restrained from.
My lord, coming.
Yes, come. You proceed slowly.
It is well settled principles of law that the entry of a person in record of right does not create or extinguish title. That entry record is only presumption of possession of in favor of the party. It is always rebuttable by everybody. It is admitted position that property originally belonged to Annada Prasad Dhari. There is no denial of the fact that Annada Prasad Dhari did not have lived 3 daughters and 1 son as his legal heirs. Whether the appellants accrued exclusive right, title, interest in respect of the scheduled property will be declared at the time of hearing of the suit. However, the respondent being the plaintiff have made out a good prima facie case so that the same may be examined at the time of hearing. There is no scope of holding mini trial at this stage. Having found prima facie case, the balance of convenience and inconvenience and possibility of suffering irreparable harm in favor of the respondent plaintiff, the learned court below passed an order of injunction directing parties to maintain status quo in respect of nature, character, or position of the suit property. The order impugned is not the order input is found not unjustified one, hence the misappeal dismissed. So their prayer was no further
First of all, in the misappeal, have you been restrained from making any construction or any sort of that?
Ye-
Apart from maintaining status quo in respect of the nature, character, and possession of the suit property.
So my lord, this is very vague one. This is not clarified.
Yes, that you have
That
agitated.
that
that you
judgment
have
in
agitated.
support of when I relied on one judgment, there must be some resemblance, or there must be some
No,
that
you
is
have agitated.
non-speaking order. This only status quo in respect of nature, character. It is non-speaking order.
Yes.
And when there
Apart from that,
and when there is a collusive suit, my lord, it is apparent because no written statement come forward. None other than myself was defending had defended the suit. None other than. There are so many 30, 40 are there. So this is with regard to my first decision. Now, my lord, second one is, my lord, hmm. 2017 volume 3 SCC 702. This is with regard to, my lord, in a suit for partition or in a suit, my lord, if any improper person implicated, and generally, my lord, I my lord, submitted that the role of a pro forma defendant. Usually, in a suit where the pro forma defendant is there, the parties want that in his presence the matter to be disposed of. His examination is not required. His written statement is not required. Pro forma defendant, only his presence. For his knowledge that this suit is going on. His participation is not required.
through this judgment, what do you
Yes,
intend?
yes. Civil Procedure Code, Section 102, disposal of High Court with a view to meet the ends of justice to avoid any further litigation between the parties concerned without dealing with all substantial question of law framed by it. Propriety direction given by the High Court to dispose of second appeal in such a manner adequately protecting interest of either party. Now, 2B, head note, order 1, rule 1, 9,
Why are you
10,
placing the head notes?
necessary parties to suit.
Why are you placing the head notes? Where the judgment is in front of you, why are you placing the head
Yes,
notes?
I'm coming inside, my lord.
Head note has not been authored by.
No. Yes. Paragraph 4, the appellant resisted the said suit by filing written statement. Appellant was the defendant. Appellants were the defendant. According to the appellants, respondent number 1 was not representing his brother Achyutan Nair, and the suit for mandatory injunction on the basis of title was bad for non-joinder of necessary parties. For non-joinder of necessary parties, here, my lord, misjoinder. The appellant asserted that they were in occupation, possession, survey number 2061, which had a clear boundary separating the property allegedly owned and occupied by respondent one. Further, the matter in issue in the present suit was already considered in the previous suit filed by the parties and could not be re-agitated once again between the parties produced evidence in support of the respective claims.
জীবনবাবু, এটা কি করছে এরা? কি করছে এরা? এখন এখন যেন কথা না বলে, যা কাজ করবে করুক, কথা যেন না বলে।
Now, paragraph 14, my lord. Paragraph 14 of that judgment, having considered the rival submission, we find force of argument of the respondent number 1 that even if the claim of respondent number 1 regarding the title over the whole of the suit property is answered against him, that does not necessarily negate his claim of being a co-owner of the suit property along with his brother. The fact that demarcation of 10 cents out of the suit property, which has been bequeathed to the brother of the respondent number 1, Achyutan Nair, under a will executed by their father, has still not been done. That would not negate the respondent number 1 from being a co-owner of the suit property along with his other brother, and to have undivided share therein. Being a co-owner of the suit property, there is nothing wrong if the respondent number 1, with a view to protect the suit property from any further encroachment, was to construct compound wall or boundary wall within the portion of the suit property as specified by the High Court. The limited relief granted by the High Court to construct such compound wall is very specific and in no manner likely to adversely affect appellant. Nothing has been brought to our notice to the contrary. Indeed, the construction compound wall must conform to the mandate municipal laws and other compliance in that behalf. My lord, I am placing this paragraph because, my lord, the court below has granted, my lord, only C schedule property, only 8.3, only 08. But I, my lord, argued the rest of the property, excepting the PWD road, that very 15 decimals, there is no whisper of party. They are saying it is not partible. So when a co-owner is coming with a plaint of partition, he must assert that all the property left by their predecessor Annoda,
Having no right, you having no right in respect of that property.
I have no right, my lord. Why I am saying so?
I got it.
The plaintiff, they have the right. Plaintiff and other defendant, excepting myself and the club, they have the right. So here, at the very beginning, it says that direction given by the High Court to dispose of second in such a manner adequately protecting interest of either party. So in a partition suit, the nomenclature is partition and inside cancellation. So when there is a nomenclature of partition, the parties to be relieved, parties to be offered the relief in respect of total property. Here only confined to C, and at the dictates of some stranger persons who is figuring in the matter, who is figuring in the suit, that could not be. A complete relief. The paragraph 14 says in a partition suit, I know that I have no right excepting 08, which I purchased through registered deed. But in the event in the event it is found that whatever they are suggesting in the plaint, that Gunodhar is the not only sole owner, sole successor in respect of that 08, in that event, the property will be apportioned. That 14 decimals, at least 14 decimals are there, and there are three portions. Three portion they can apportion. I can be saved myself, and I submitted before your lordships that if 08 C schedule is left out, I have no problem. I'll surrender. I will not contest the suit because I am the purchaser, bona fide purchaser. I purchase a property through possession, with possession. So I have no interest. Whether they deprived or they benefited, I have no. But since my vendors, they are figuring as co-owners. For that reason, it should be submitted from their behalf. But unfortunately, since this is a collusive suit, there was no detailed statement other than myself.
So, in this paragraph, you are in this judgment you are relying upon
14, complete justice, complete share.
Next. How many more do you have?
No, only 3. I yesterday I indicated.
That is more than enough.
Bit faster,
My
Mr. Kodre.
lord, this was 2017 3. Last
one was yes,
2017 3.
you have 2017 volume 3 SCC 702.
702. It is, my lord,
Earlier one
2017 6. 2017 6. 778 SCC.
Din.
8 and
Relying upon which paragraph?
necessary parties.
14.
এটাই তো দিলাম না কি 17 6টা দিয়েছিলাম
3 দিয়েছেন 3
3 দিয়েছিলাম
আর 2006 ভলিউম 3 দিয়েছেন 2017 ভলিউম 3 দিয়েছেন এবার এটা 6
Herein you are referring to paragraph 14.
না না এটা একই তো দেখছি
আর ওই দুটো দুই জায়গায় রিপোর্টে
না মানে পেজ 702 কি দিলাম
778 2017 volume 6 SCC 778. The earlier one was 2017 volume 3
702
702.
ও ওটার 14 যাই হোক এটা দেখছি এটা
This is not applicable.
No, applicability is there. Kindly see from the head to necessary parties to the suit. Who are the necessary parties? Yes, all relating to my lord. All relating to my lord. Partition suit.
You have seen that word, necessary parties, and you are providing that.
My lord, only two.
Any more?
No. And my lord, one thing, my lord.
So you are relying upon
After the death of Annoda Prasad, all along, names of the Gunodhar Dhali is appearing. Names of Gunodhar Dhali is appearing in the record of rights. No problem. No other co-sharer, alleged co-sharer, has ever come forward for rectifying it, or has ever raised any objection to that. So they have full knowledge. They waived it. They accepted it. কোনটা? কোনটা দিয়েছিস কোথায়? দিয়ে দেবো জজ সাহেবকে? Well, this is the order of trial court's final order.
Shall I start?
Yes.
Lord, so far as the statement, I will take 20-25 minutes. 20 to 25 minutes.
So
Lord, so far as
other matters are released.
so far as Lord, the submission made by my learned friend,
Those matters will appear tomorrow. Because during the second half, there's another
Other.
bench.
so far as the submission of my learned friend with regard to two factual aspects, that the injunction order was passed. The injunction order was passed in the form of status quo, and the both parties were directed to maintain status quo. There is no interim order of injunction has ever been passed in the instant application. This is the first aspect.
At the time of ad interim temporary
At the
injunction.
time of ex parte ad interim order of injunction,
Injunction,
no interim order
quo in
passed,
respect of-
status quo order was there. Second battle, when they appeared, they filed their written objection.
after contest during the temporary injunction.
That is also status quo.
Same order status quo.
Yes,
And in the misappeal also.
yes,
Same order of status quo.
grateful. Now, second, this is the wrong submission made by my learned friend. The second aspect is, my lord, the prayer of the suit. Although, my
A.
lord,
Prayer A.
prayer A. My lord, although, my lord, I will submit before your lordship that injunction hearing cannot be converted into a mini trial. That yesterday I
That
was
has been stated somewhere. It has been
in
stated.
many judgments, my lord, you will find, my lord, I will.
Herein only.
Yes, in misappeal.
I think
by
in the misappeal.
yes, at the time of dismissal of their misappeal, the learned judge has, my lord, specifically stated that. And so far as the several judgments of this honorable court and the honorable apex court, there are many cases are there. I will cite, my lord, only 2 or 3 judgments on that.
Don't cite more.
Not
And
more,
on one
not-
issue, one judgment.
So far as the prayer of A is concerned, your lordship kindly have a look the prayer. Page 38. Page 38 of the plaint, that is the prayer portion. A decree for declaration that the registered deeds of conveyance of this as described in item number Roman capital 1 and 2 in the D schedule below to the plaint are illegal, void, fraudulent, invalid, vague, baseless, and not binding upon the plaintiffs as well as upon the defendant numbers 9 to 31. No cancellation has been sought for. There is no prayer that the deeds must be cancelled. This is the prayer. Your lordship kindly sees the valuation part. The valuation of the suit is valued at 1,20,000. The deed value was 30 lakhs. So that is absolutely wrong statement made by my learned friend. This cancellation has been prayed for. Upon declaration that the deed which has been executed, both the deeds, either executed in the year 2015 or in the year 2023, is not binding upon me. That is fraudulently executed by the parties, by the heirs, precisely by the heirs of Ananda Mohan Dhali, one of the heirs. The partition suit, my lord, is with respect of C schedule property, because A and B has been described exactly in the plaint. A schedule property is total 23 decimal of land. Thereafter, 1966 or 65, a acquisition proceeding was initiated. Mr. Dhali, the original owner, was notified. He contested. 15 decimal land has been acquired. Now, rest 8 decimal land is the subject matter of the partition. That is Schedule C. There is no ambiguity in this, because plaint and and the injunction application is very much clear. And that is why in every order, the restriction was made upon the Schedule C, which is 8 decimal of land. Now, so far as the argument which has been made by my learned friend with regard to partial partition, club was made party, cancellation of deed in the year which has been executed in the year 2015 and thereafter 2023, 3 years limitation, not from the execution which has been said, but from the date of knowledge. Now, whether the suit is barred under section 34 of this specific relief act, or the provision of order 2 or rule 2 of the code of civil procedure is applicable here is not. The function of attesting witness in the 2015 deed, which is the predecessor of the plaintiff number 1 to 3, these all aspects are to be decided in the trial. The prima facie case, which has been, your lordship knows very well, better than me, the 3 aspects is required to be considered at the time of hearing of the injunction application. Prima facie case, balance of convenience and inconvenience, and irreparable loss and injury. The main point which has been raised by my learned friend is this: whether original owner A. Dhali was expired before the enactment of 1956 Act or not. We have specifically stated that in the year 1970 he expired, because prior to that 60C, in the year 1966, the acquisition process was there. He has participated in the acquisition process. Thereafter, it will reveal further from the evidence when the trial will commenced. Now, at this stage, their contention was 1956, before enactment of 56. That is why the daughters are not succeeded the property, interest of property of Mr. A. Dhali, the original owner. He has stated that daughters are the existence of daughter. They have raised question, the existence of daughter. However, in paragraph number 10, if this revisional application, they have specifically stated that daughters are excluded since Mr. A. Dhali expired prior to 1956. Not in WO or WS, but in revisional application, in paragraph number 10, your lordship kindly sees page 12.
Paragraph 10.
That said, Ananda Prasad Dhali, who died intestate sometime in 1955, leaving behind her only son Gunodhar Dhali, who survived all the estate of Ananda Prasad Dhali. Suroju Dhali, the wife of Ananda Prasad Dhali, predeceased him, the daughters having no right of inheritance at that time. So, existence of daughter by this statement has been admitted. Your lordship kindly sees the affidavit portion of this revisional application, page 16. Page 16, your lordship kindly sees the statements contained in paragraph number 1 to 12 are true to my knowledge. So he is affirming this is his knowledge. This is in his knowledge that daughter has no right of inheritance. So existence of, he cannot play two roles in two courts, in two jurisdictions. He has specifically stated in his, either in his written statement or written objection, although no specific case has been made out, nothing has been stated, no document has been forwarded, only two deeds, which has been challenged by us in our partition suit in the form of declaration. This is not one aspect of admission of the existence of the daughter. And the second aspect is, Milord, your lordship kindly consider, they are saying, as per their version, in 2015 deed, one Mr. Osit Bachayat the predecessor of the plaintiff 1 to 3, attesting witness. He has spelled out 3 or 5 times that co-owner. If the Gunodhar Dhali is the only owner of the property and there is no other daughter or son exist, then how come Mr. Asit Bachat is coming in the year 2015 and executing the attesting the the execution of the deed? So they are admitting there are other co-owners are there. They are by saying this that Asit Bachar was there. You cannot say now by filing this plaint as a heirs of the Asit Bachar, who was the original co-owner with Gunodhar Dhali. That means, they are admitting the other existence of other heirs of original owner of Mr. A. Dhali was there. So this is the two aspect, they have not spared anything in their written objection. Evasively, they touch everywhere, try to raise dispute with regard to the possession and other things, club and other things, saying all these things. But in fact, the prima facie case which has been made by us, by the plaintiff, is absolutely not pointing on the issue that the other heirs are there. They have been made party. Whether they are contesting or not, your lordship knows partition suit. Everyone is plaintiff, everyone is defendant. No need to contest. The court, after finding the ownership or the share, will be distributed accordingly. The defendant is not need to be added as a party or to appear as a to contest. It is automatically distributed. The plaintiff is filed and sued and saying that I have this share and this defendant has that share. It is not required by any defendant to say and contest the suit by filing any written statement. This is automatic because party without undivided property can be partitioned by dint of a deed or decree. Here, the partition suit has been filed. More so, he has, stated the defendant number 1 and 2, particularly stated that Gunodhar Dhali is the absolute owner. And he has got the entire C schedule property. That is why challenge has been made. Because other heirs are there. That is to be, adjudicated. Whether Mr. Dhali, original owner, expired in the year 1955 or 1970, as we have stated. The evidence will be adduced by the parties. The trial will commence. Every document will be placed. Initial prima facie, your lordship kindly sees from the order itself that all the documents to satisfy the court, all these aspects has been forwarded by the plaintiff. Not a single document by the defendant, because we have forwarded the 15 deed, certified copy of the 15 deed and 23 deed.
Yes. Next point.
So, now at this stage, your lordship kindly sees that at this stage of injunction, when the injunction hearing was commenced, without producing any document or even saying any date, we have said, 1970. First time they are saying in this revisional application, 1955. They did not say anything regarding the date of death. They have floated their statement, they have floated their case make out evasively, and on that issue, they are demanding everything.
In the written statement or in the written objection,
Yes.
whether specifically it has been mentioned anywhere
No.
about the date of death?
Nothing, Lord. They have denied the existence of the daughter. But saying that 2015, plaintiff's the predecessor was there who attested the deed, execution of the deed. Your lordship already, my lord, observed the power of the attesting witness, the scope of the attesting witness.
Yes.
Initially, my lord, at the time of ex parte hearing, the injunction application can be heard, my lord, without even looking into any document, on the basis of the plain case and the written and the application, injunction application case. The prima facie satisfaction of the court is required. If the learned court satisfied that there is prima facie case and there the suit or the application for injunction is required to be heard after giving notice to the other side, then the interim order was passed, and usually passed, and the service was made, thereafter contested. When the contest is being Milord, hearing is started, both the parties, Milord, joined by filing their respective documents and the affidavits. Here in this case, Milord, we have produced some documents. Your lordship can see from the, it will be
What
reflected.
Which documents?
Documents, Milord, error record and other documents has been filed, Milord. That is the, Milord, that has been considered by the learned court. Your lordship kindly sees the.
Is it mentioned?
Yes, yes. In the judgment, your lordship kindly once again, your lordship kindly sees the first judgment of the court that has been handed over just now by my learned friend. Even at the time of ex parte ad interim order, we have produced document. That is also there. Your lordship kindly sees 20th September 2024 order.
Yes, 20th September.
Yes. First, Milord, today is fixed for passing order, such and such, and application under section such and such, supported by affidavit for extension. The case records taken up for passing order. Peruse the the application under order 13 and rule 1 and 2, read with section 151 CPC dated ATO, filed by the plaintiffs, written objection dated such and such, filed on behalf of the defendant numbers 1 and 2, counter affidavit dated 12th of September 2023, filed by the plaintiffs, documents filed on behalf of both sides, and other materials available on record. Everything has been produced, everything has been considered, everything has been before the learned court.
Yes.
And my lord, after considering all this aspect, my lord, the learned court, not only the senior division but also the learned additional district judge in misappeal, my lord, sustain the order of my lord injunction. No, attesting witnesses, that is the subject matter of trial. Attesting, whether attesting witness has any right to dispute the deed itself after so long years, whether the knowledge, because 3 years from the date of knowledge, whether the knowledge is 2023 deed or 2015 deed, that will be taken into consideration in the trial, not by this the either of these injunctions, the senior division or additional district judge.
As regards to the order of status quo.
Order of status quo was passed, my lord, so far as the your lordship knows, on the basis of this, why this suit has been filed.
It has not been specifically mentioned. That is the allegation.
No, my lord, this specifically mentioned, my lord, everything has been discussed. After discussion, my lord, after my lord, observation made by the learned courts below, this order of status quo has been passed. And my lord, significantly, the order of status quo has been passed, my lord, for restraining both the sides to maintain status quo.
Yes.
Now, my lord, I want to show, my lord, your lordship, two judgments, my lord. One is single bench judgment reported in 2024 to ICC 496, PL Jain versus Ashish Mukherjee. The relevant paragraph is paragraph 25 and 26. Your lordship can see, thus this court does not find any illegality and or material irregularity in the order impugned. The learned trial court ought not to have refused the ad interim injunction only on the basis of ad interim order of status quo passed in title suit number such and such. The order of the learned trial court suffers from non-consideration of the materials on record. Any further proof by this court would amount to holding a mini trial at the stage of deciding whether an ad interim injunction should be granted or not. Reference is made to the decision of Ananda Prasad Agarwal versus Tarakeshwar Prasad and others reported in 2001 5 SCC 568. The Honorable Apex Court held that it would not be appropriate for any court to hold a mini trial while deciding the application for injunction. The only consideration are prima facie case, balance of convenience, inconvenience, and irreparable loss and injury. In my considered opinion, all such factors were taken into consideration by the learned lower appellate court. This court is not required to substantiate its decision by interfering with the discretion exercised by the learned lower appellate court, as the exercise of discretion was neither arbitrary or capricious nor perverse. Scope of interference in the supervisory jurisdiction on the decision of a fact-finding forum is limited.
Yes.
Now, thereafter, your lordship kindly consider another judgment reported in 1994,
1994 1
for
CLT.
once CLT, page 58, paragraph 13.
Paragraph 13.
Paragraph 13, 1-3.
Yes.
May I read, my lord?
Mm.
Regard being had to the facts and circumstances of the present case, we think that the plaintiff respondent number 1 really does have an arguable case which warrants a full-throated hearing on merits. There is no such rule as was held in American Simamid Corporation Ethicon Limited, that court is not entitled to take any account of the balance of convenience unless it has first been satisfied that if the case went to trial upon no other evidence than it is before the court at the hearing of the injunction application, the plaintiff would be entitled to judgment for a permanent injunction in the same terms as the interlocutory injunction sought.
As the interlocutory.
As this would be as.
Yes.
The use of such expression as a probability, a prima facie case, or a strong prima facie case in the context of the exercise of discretion, any power to grant an interlocutory injunction leads to confusion as to the object sought to be achieved by tints from of temporary relief. The court no doubt must be satisfied that the case is not frivolous and vexatious, or in any other words, but there is a serious question to be tried. It is no part of the court's function at this stage of the litigation to try to resolve the conflicts of evidence and affidavit as the facts on which the claims of either party may ultimately depend, not to decide difficult question of law which call for detailed argument and nature considerations. These are matters to be dealt with at the trial. So unless the material available to the court at the hearing of the trial, at the hearing of the application for an interlocutory injunction fails to disclose that the plaintiff has any real prospect of succeeding in his claim for a permanent injunction at the trial, The court should go on to consider whether the balance of convenience lies in favor of granting or refusing the interlocutory relief that is sought. Where other factors appear to be evenly balanced, it is a counsel of prudence to take such measures as are calculated to preserve the status quo. If the defendant is enjoyed temporarily from doing something brat he has not done before, the only effect of the interlocutory injunction in the event of his succeeding at the trial is to postpone the date at which he is able to embark upon a course of action which he has not previously found it necessary to undertake. Whereas to interrupt him in the conduct of an established enterprise would cause much greater inconvenience to him, since he would have to start again to establish it in event of his succeeding at the trial. We think that the trial judge rightly came to the conclusion that the balance of convenience lay in favor of his exercising his discretion by granting an interlocutory injunction tentatively for some time, and as an appellate court, we should be hesitant to overrule the trial judge's exercise of his discretion unless are absolutely satisfied that he has gone wrong in law. In view of the fact that there are serious questions to be tried upon which the available evidence in incomplete, conflicting and untested, to express an opinion now as to the prospects of success of either petty party would not only be embarrassing to the judge who eventually is to try the case, and that is why we desist from dealing with the existing evidence in detail and from giving reasoned assessment of our own views as to the relative strength of each party's case. At this stage, the court is not entitled to decide what is the correct answer to be given to the question at the hearing of the suit, but merely whether there is a fair point for trial, in the sense that there is a substantial question to be investigated and that the matter should be preserved in status quo until the question is finally disposed of. These are, my lord, the two judgments. The judgment was there, but that deals with your lordship judgment sitting with my lord Justice Sobhasati Bhattacharya. That is, my lord, dealt with the ex parte order. So I am not, my lord, giving much emphasis on that. So this is my submission. My lord, the trial court and the landed first appellate court rightly, my lord, directed the parties to maintain status quo because he is trying to construct or making construction over the suit scheduled property. If the scheduled property is being construction is being made, the partition suit and my suit for declaration of those deeds will become infructuous. These are all my submission.
In reply, I should say that whatever I submitted regarding maintenance of the suit, since it is hit by limitation, that was not answered. Well, and friend suggested that his client only paid for declaration. It is fraudulent, it is not binding upon his client. So court when finds it is not binding upon him, the court, what the court will do over the instrument? Court will not cancel it. Court will certainly cancel it. And he is saying that it is knowledge, from knowledge. Not a single sentence is there in the plaint or application that his knowledge about the transfer came in such and such date. Nowhere is there. A very vital thing which I agitated since last 2 days in my argument, that what about B schedule property? Club will be the owner. No whisper, no answer. It is whose interest? This matter, this partition suit, under the garb of partition suit, this suit is for whose interest? He is representing whom? Co-owners or the club? No whisper about the B schedule property, school, function, playground, Durga Puja, stalls, bazaar, hart, and revenue is going in whose pocket? Not the all co-owners are entitled to. So this is the suit which is speculative and collusive. from the judgment, my learned friend cited, unless there is vexatious pleadings, vexatious suit, speculative suit, this privacy is okay. But the agitation which my client made in the trial court, appellate court, here before your lordships, no answer. What about the B schedule property? No, they are not entitled to. They are foregoing their interest. They are much interested about 0.8. They are not interested about 15 decimals. Who will be the owner? What will be the fate of that property? Club will be the owner. No whisper, no answer. So if the court directed to maintain status quo in respect of 8 plus 15 minus road, which was captured by, which was constructed, I have no problem, because everything is at the interest of all the co-owners, all the heirs of Annoda Prasad. He is telling, I have disputed the 3 daughters of Annoda. No, my twofold submission. One is, it is my knowledge, my clients gathered knowledge that Annoda Prasad died in 1955, and from the genealogical table manufactured by the club, my lord, kindly have a look.
No, Mr. Poddar.
Probably,
Only on the point of law.
yes. So if the main portion, B schedule, is remain unanswered, I submitted this is a collusive suit, because the participation of the local club secretary president, who are wrongfully enjoying the property by depriving all the legal heirs of Annoda Prasad, no answer. So if on factual argument, if there was no whisper, no answer, that stands admitted. And harassing, speculative and vexatious suit, it is accepted by my learned friend without answering all the B schedule property. I never disputed that they are not our legal heirs. I only said twofold submission, since only Dhali's, Gunodhar Dhali's legal heirs sold the property. I say probably either they, from the papers, it is found that some date of death was mentioned. One of them, the Annoda Prasad, 1955. And in support of their contention before the trial court, there was no death certificate. They just in corroborative measure, they took that settlement case 28 in 1965-66. Personally service was done. What is that proof? Personally service. What is the proof that the heirs of Annoda Gunodhar or Annoda Prasad Dhali received compensation? What is the proof that he participated? He adduced evidence. What is the judgment? Where? Where? And he is saying mini trial can be done by whom? Plaintiff had not satisfied about the B schedule property. Plaintiff has not satisfied. Why so long they remain quiet? Plaintiff has not satisfied. Why they compelled to make the club as a performer defendant? What for? It is new. It is completely new in a partition suit, under the guise of partition suit. The club would be made party. It is not a PIL. It is not PIL. And my predecessor, Annoda Prasad Dhali, left the property not for the welfare of the public. Club, local club, Mela.
Complete.
So there was no answer regarding B schedule property. So this suit is speculative. This suit is so in a such type of suit, which from the very beginning, which we are seeing, we are finding in those proceedings, in those suit, any type of injunction order,
Such order ought not to have been passed.
and is illegal.
Learned counsel representing the petitioner further commences his submission.
Collusive suit, collusive.
Further, further comments his submission, and in support of his submission has provided, has cited two judgments. Those are 2017 volume 3, two judgments published in, those are now published in 2017 volume 3 Supreme Court cases 702 and 2006 volume 3 Supreme Court cases 312. The learned counsel, paragraph, the learned counsel representing the opposite parties has also submitted exhaustively, and in support of his contention has provided, has relied upon pre-authorities published in 1994 volume 1 Calcutta Law Times, CLT করে দিলেই হবে, CLT page 58. Next হচ্ছে 2024 volume 2 ICC page 496 and দুটোই two. Argument is completed, reserved for judgment. এগুলো এনভেলপে যাবে, এনভেলপে দিয়ে পাঠিয়ে দেবেন, দুটোই এনভেলপে দিয়ে। সেকেন্ড তো ওই ডিভিশন বেঞ্চ আছে।